This is Bloomberg Law with June Grasso from Bloomberg Radio.
This act of terrorism and the violence that stems from it is something that would not be tolerated in the city. We wanted to personally be here to show the symbolism of leading from the front.
It's never happened before. The mayor of New York City meeting the aircraft transporting a murder suspect. And it was quite a spectacle at a Lower Manhattan heliport on Thursday afternoon as Luigi Mangione, dressed in a bright orange jumpsuit and handcuffed, made the long walk from a helicopter to a waiting SUV, surrounded by heavily armed law enforcement officers wearing bulletproof vests and carrying long guns, and following behind Mayor Eric Adams and the New York City Police Commissioner. The so-called perp walk was a complete departure from the way federal authorities normally handle the transfer of suspects. But the handling of the Mangione case by both state and federal authorities seems to be a departure from other criminal cases in many respects. The 26-year-old Mangione is accused of the brazen murder of United Health Group CEO Brian Thompson, allegedly shooting him from behind with a 9mm ghost gun on December 4th. On Tuesday, Manhattan District Attorney Alvin Bragg announced the indictment of Mangione on 11 counts, including first-degree murder, saying the shooting was a carefully choreographed act of terrorism.
As we allege, the defendant in that case brazenly shot Mr. Thompson twice in Midtown Manhattan, was targeted, premeditated, and meant to sow terror.
And then, before Mangione was even arraigned on the state charges, the federal government unexpectedly charged him with murder and stalking, with one of the charges carrying a possible death sentence. Joining me is Palm Beach County State Attorney Dave Arenberg. Dave, I've never seen a perp walk quite like this. And the feds don't usually do perp walks or photo ops. Why here?
Wow. This is an internationally watched case, and he's being treated differently. The reward money was larger and faster in coming. The attention given to it is much greater than any other case. He's a folk hero among some, and I think this is a statement meant that you're going to treat him like the criminal that he is as opposed to a big-time celebrity. But in so doing, it looks like they're treating him as a celebrity. And so nothing about this case seems to be normal.
So murder is generally not a federal charge. There were almost 400 homicides in New York City last year, and you didn't see the federal government getting involved. So why are federal prosecutors filing charges against Mangione in the case of a murder that happened in New York City?
Well, if this was the Trump administration, I'd say it's because they don't trust the Manhattan DA. But this is still the Biden administration. And I think just because of the international interest in this case that they're coming in to make sure that nothing goes wrong at the state level. It's like a backup. But it is unusual because usually it's one or the other, not both. But there's nothing usual about this case. And I think one of the reasons why the federal government is getting involved here, it's important to them and to a lot of people that there's not a precedent set that glorifies murder. And right now we're seeing too many people glorify this murder and treat him like a hero when he killed a father of two. And he did so by lying in wait, wearing a mask, waiting for him to walk by, and then shooting him in the back and then running away. Not quite an act of heroism.
Federal prosecutors could seek the death penalty for the count of using a firearm to commit murder. Whether to seek the death penalty involves a process within the Justice Department. Do you think they're likely to go that far?
I do think that based on Donald Trump's statements about this case, that in the next administration, they could seek the death penalty, even if they don't seek it initially, because right now there's a moratorium on the death penalty at the federal level. But that's going to change. And so, yes, I do think maybe that's one difference between the state and the federal systems here is that the death penalty is outlawed in New York, but a federal case can impose a federal death penalty. I think there would be a lot of outcry, though, because this guy's got a bunch of supporters, and I think that ultimately a jury will not give him the death penalty in this case, but the feds may try.
His attorney, Karen Friedman Agnifilo, said in a statement that the dueling state and federal charges raise double jeopardy concerns. Of course, double jeopardy prevents a person from being tried more than once for the same crime. Do you think these dueling prosecutions violate double jeopardy?
Not really, because there's something called the separate sovereign doctrine. These are two different sovereigns, state and federal, and they can both file their own charges based on their own laws. And so you could have that. Now, in some states like New York, there are additional restrictions on states that then pile on. You saw that with Paul Manafort. In fact, the Paul Manafort indictment that came at the state level was thrown out by the courts because of double jeopardy concerns. Now, the feds, though, don't have the same type of restrictions, and federal law generally will permit a piggyback type of case like this, as long as it's not the exact same statute, which it's not. These are two separate statutes and two different types of penalties. In the federal system, you can get the death penalty. The state system, you don't. So I do think they'll move forward. And I do respect Karen. She's a great lawyer, and I think she has an argument that the state does seem to be overreaching here with the first-degree murder charge, but I would disagree with her on her statement that the feds are engaging in double jeopardy in adding their own charges. There's a lot of case law that says they can do it.
I think the federal charges came as a surprise even to the Manhattan District Attorney's Office. Mangione's attorney was apparently ready for his appearance in state court when it was suddenly changed to federal court, and she told the magistrate, frankly, I've never seen anything like what's happening here in more than 3 decades of practicing law. Because the feds swooped in, Mangione still hasn't appeared in state court for his arraignment on the state charges. It seems like the federal prosecutors and the state prosecutors are, at this point, not coordinating well.
Well, it wouldn't be the first time. We saw this most recently in the second assassination attempt against Donald Trump, where you have the feds getting an indictment against the attempted assassinator, and then you have the state of Florida doing a conflicting investigation that has led to state charges. So we're seeing these turf wars more and more. I don't think that's a sign of progress. I think that's a sign of the times, unfortunately.
Let's turn to the first-degree murder charge in New York with the terrorism enhancement. And the DA said that Mangione intended to intimidate and evoke terror with the killing. Is that an overcharge? Is he reaching there?
I respectfully do believe that they're reaching a bit. I think it's an easier case to prove second-degree murder, and I realize that they included second-degree murder, and they may want to push a compromised verdict, which would be second-degree murder, where he could face up to life in prison. But I do think when you add the first-degree murder charge, it feels like an overreach, and that could cost you some credibility in the eyes of jurors. You look at the prosecution of Daniel Penny, that's the ex-Marine who killed Mr. Neely on the subway. Well, they charged him with manslaughter, and a lot of us thought that was an overcharge. And apparently it was, because the jury couldn't reach an agreement, and then finally the judge threw it out. And then when it came down to the lesser charge, the easier charge, the jurors had enough and just said, no, acquittal. And that's the kind of thing that you worry about when you overcharge, that you have juror fatigue, you have juror mistrust at prosecutors. So you have to be really careful here. And I just don't think, based on what we know now, that you can confidently say that this was an act of terrorism, but maybe, they have access to information that the rest of us do not have. So we'll see. But as of right now, I do think it's a bit of a reach.
When it was just the state charges, it seems like they could have been trying to push him into a guilty plea to avoid life without parole. Now things are more complicated with the added federal charges. Would the defense only agree to a plea or pleas if they could get deals with both the state and the feds?
It complicates things for the defense, because you could plead guilty to state charges and then still face federal charges. So you want a deal that will cover everything. And with the feds and the state seemingly in conflict with each other, that makes it harder for defense lawyers to say, all right, everyone, let's all come to the table. Here's one universal settlement. The feds may seek the death penalty. The state is looking for first-degree murder, but there is no death penalty there. So there's a lot of moving parts here. And with two different cases, maybe they want to ramp up with more attorneys. They can afford it. The defense has lots of money, because this is getting a lot more complicated.
Before she was hired to represent Mangione, his attorney Karen Friedman Agnifilo suggested on CNN that there might be an insanity defense here. By all accounts, the evidence against him is overwhelming. Is not guilty by reason of insanity the way to go here?
I don't think the insanity defense is a good defense here. I don't think that will play. And the reason is that to have an insanity defense, you have to have an established medical condition, and you cannot know the difference between right and wrong. Well, when you wear a mask and have fake IDs and meticulously plan for a murder, you're definitely able to distinguish between right and wrong. You know what you did was illegal. You know how we know? Because you planned for it to not be caught. And then after you ran away and hid and tried to conceal your identity, well, that shows you knew the difference between right and wrong. You knew what you did was illegal. You knew the consequences of your actions. So I don't think they have much of a chance at an insanity defense. Now, they could have a different defense to claim that he was under extreme emotional disturbance, which would make it more of a manslaughter case than a murder case. That could get you between 5 and 25 years in prison as opposed to up to life in prison for murder. That may be a better defense, not a complete acquittal, but something less than murder. And then there's always the specter of jury nullification. It's a prosecutor's worst nightmare, where the jury just feels sympathy for the guy and ignores the evidence and ignores the law and then just sets him free. That's always a possibility when you're dealing with this kind of unusual case of a defendant who will probably take the stand and probably gain some sympathy from the public, if not members of the jury.
So jury selection, which is always important, will be critical in this case. Thanks so much, Dave. That's Dave Arenberg, Palm Beach County State Attorney. Manhattan prosecutors say Mangione will be back in court on Monday, in state court this time, to enter a plea on the state murder and weapons charges. Coming up next on the Bloomberg Law Show, the Supreme Court fast-tracks TikTok's free speech challenge to the law banning the popular app on January 19th if it's not sold by its Chinese parent. Remember, you can always get the latest legal news by listening to our Bloomberg Law podcast wherever you get your favorite podcasts. I'm June Grasso, and you're listening to Bloomberg.
I have a warm spot in my heart for TikTok because I won youth by 34 points. And there are those that say that TikTok had something to do with that.
President-elect Donald Trump may have a warm spot in his heart for TikTok, but the ban on the wildly popular app will go into effect on January 19th, the day before he takes office. So it will be up to the Supreme Court to decide on the app's survival. This week, the justices agreed to fast-track TikTok's free speech challenge to the law that will ban the platform nationwide if it isn't sold by its Chinese parent company. They'll hear arguments on January 10th, TikTok's final legal chance to halt the ban. And it appears to be an uphill battle after the D.C. Circuit Court unanimously upheld the law this month, finding it was a legitimate means of protecting national security and user privacy. Joining me is Eric Goldman, a professor at Santa Clara University Law School and co-director of the High Tech Law Institute. Eric, the court has scheduled a special argument day to consider the ban in less than 3 weeks. It's allotted 2 hours for the arguments. That's double the normal time. How unusual is this, and what does it signify?
Every Supreme Court case is unusual. It's one of the rarest events in litigation. But this case is unusual for the Supreme Court's procedure. They've set up an expedited process that they don't normally follow, and it means that they're going to be moving fast, but they're probably also not going to be able to issue this kind of quality of opinions that we're used to. So they're probably going to have to cut some corners along the way as well. So this is an unusual case for them.
In the Bush v. Gore case, the court ruled the day after they heard oral arguments, and just 3 days after they agreed to take the case. Do you think that with this expedited schedule, they're planning to issue a decision before January 19th when the ban goes into effect?
I don't think they would have built a schedule like this unless they plan to give some ruling before January 19th. But you mentioned Bush v. Gore, and that's actually a good example of the problems that are awaiting the Supreme Court. Not only was that opinion fragmented in the sense that every judge wrote for themselves, but also that opinion has been roundly criticized as being not the same kind of standard quality of judging that we expect from the Supreme Court. So this Bush versus Gore example is actually a cautionary tale for the Supreme Court. Odds are that they're going to issue multiple opinions and that it might not be to the level of quality that we want.
The justices could have temporarily blocked the law while considering the case. That would have taken 5 votes, while hearing the case just takes 4 votes. But wouldn't that have been a better way to handle this?
As an outsider, it looks like what the Supreme Court should have done was put the law on hold until the Supreme Court could do a standard process for its review, not do this expedited corner-cutting approach. And I don't know why they didn't do that, but that's the choice they made. And so they've clearly decided that they're going to have to move faster.
Are they balancing the First Amendment against national security concerns and the court's deference to Congress and the executive branch in making national security decisions?
That's a good summary, but if you don't mind, I'm going to restate it a little bit.
Absolutely.
The D.C. Circuit, which heard the TikTok case and has sent the case up to the Supreme Court, said that the law was censorship, that the law censored TikTok and its users. But nevertheless, that censorship was justified on national security concerns. That creates really two tracks for the Supreme Court to pursue. One track they could pursue is to say the law is censorship, and yet it survives, like the D.C. Circuit said, because the national security concerns outweigh the loss of free speech. Another track is that they could say, we agree that the law is censorship, and that's a reason why it should be struck down. And so the D.C. Circuit's opinion that presages the Supreme Court's review really set up the Supreme Court to answer that fundamental question: under what circumstances does national security override what is on its face, and everyone seems to agree, is just censorship.
Some TikTok users seem to be waking up to the fact that it may be gone. Do you think the court will address the concerns of the 170 million U.S. users?
I'm hoping that the court will be sensitive to the fact that not only does TikTok have free speech rights, but so do all the millions of users, millions of Americans who are talking to each other on TikTok. And even if we disregard TikTok's interests, we still ought to care about the conversations that are taking place by and among Americans on TikTok that are all in jeopardy due to this ban. The D.C. Circuit really didn't care about that issue. They just lumped it together under the broad heading of TikTok's concerns. They didn't otherwise pay attention to TikTok's users' interests. I'm hopeful the Supreme Court will be more sensitive to that, but we'll have to see.
The Roberts Court has been very protective of First Amendment speech rights, as well as national security interests. Do you have any idea of how they might rule here?
It's hard to predict what the Supreme Court's going to do because there really are two different dynamics pushing them in opposite directions. Back in July, the Supreme Court issued a very strong endorsement of the First Amendment protections for social media. And so if we look at what the Supreme Court has said just a few months ago, they said, if it's censoring social media, that sounds like a First Amendment problem. On the other hand, you have this D.C. Circuit opinion that was a unanimous opinion saying that the national security concerns here overrode the free speech concerns. And the Supreme Court listens carefully to the D.C. Circuit. It's a well-respected court. They put together an opinion that was designed to be persuasive for the Supreme Court. So if we look at what the Supreme Court said in July, it looks like the TikTok ban should not succeed. If we look at what the D.C. Circuit advised the Supreme Court, it looks like the ban should be upheld. And so I don't know which strand is going to override the other. I wouldn't put money on either side of the equation, TikTok winning or losing at the Supreme Court. I just view the risks as being too hazy to really make an educated gamble. But I also think that the Supreme Court is open to an alternative outcome, given what they said in July.
So what are the other possible outcomes besides an outright win or loss?
One possibility is the Supreme Court says that it can't reach a final decision and that additional work needs to be done by lower courts. So we get a non-answer from the Supreme Court. Another possible outcome is that the Supreme Court upholds parts of the ban and strikes down other parts. I don't really know what that looks like. We'd have to see. But the point is that it's not as easy as just does the Supreme Court uphold the ban outright or not, because there's a whole bunch of other tools in the Supreme Court's toolkit.
Trump takes office the day after the TikTok ban is supposed to go into effect. He's been all over the map about TikTok over the years. He met with executives of TikTok at Mar-a-Lago this week. Let's say he does want to do something to save TikTok. What could he do?
By the time Trump takes office, either the TikTok ban will be enjoined permanently or temporarily, or it will be in effect. So the law has a mechanism that gives the president some discretion with respect to TikTok, but only Biden will be able to exercise that. So that particular option in the statute to delay the effectiveness of the law won't be available to him. So at that point, Trump really has two choices if he really wanted to protect TikTok. First is he could go back to Congress and ask Congress to rethink its ban. I don't think that's going to go anywhere. Even Trump's most loyal fans have been very solidly against anything that looks like it would benefit China. And so I just don't think that even if Trump asks, he's going to get a majority of Congress to change their mind. The other thing that Trump can do is that he could ask the Department of Justice not to enforce the law, that the Department of Justice could take a voluntary stance that though the law is in effect, they're not going to devote any prosecutorial resources to it. Trump doesn't have the power to tell the DOJ what to do. He has to ask. In practice, if he asked the DOJ to do something or not, they would likely do it. However, that only works if everyone around the Department of Justice believes that the Department of Justice won't actually change its mind. And that depends on believing that Trump won't change his mind. And given how mercurial Trump is, how often he has changed his tune, I don't think anyone would believe the Department of Justice if it said that it wasn't going to enforce the law. I just think that everyone would view that as a short-term statement subject to change and not make any decisions in reliance on it. So I really don't think Trump has any valid options to walk back the ban. He'd either have to go to Congress or he'd have to ask the DOJ to do something, which I don't think would really make a difference. So this ban is real, and it's unfortunate that so many Americans don't realize that this ban is coming for them.
So people say, well, I have TikTok on my phone. I'm still going to use it. Explain what happens if this ban goes into effect.
I'm still a little unclear about exactly what would happen post-ban. We know that new downloads will become extremely difficult, if not impossible. So the ban affects the app stores. The app stores are going to do whatever the government tells them to do. And so if the government tells them to take the apps out of their app stores, they'll do it. So in addition, other service providers in the U.S. are supposed to not provide support to TikTok. And I don't exactly know what implications that would have for the experience of the users who already have installed the app. I think what's likely to happen is that the app is going to start a death spiral. It won't happen overnight, but over time, people will invest less of their time, or content producers will invest less in producing TikTok content. And so over time, it becomes a ghost town. That might take months or years, but by stopping the inflow of new users and by making it harder for existing users to take advantage of it, I just think people will start to migrate elsewhere.
Yeah, in its papers, TikTok said that being shuttered for even 1 month would cause it to lose a third of its U.S. users. But
and it's not just losing the users outright. It's also that users are just going to invest less of their time, or content producers will invest less in producing good content. People are just going to take their marbles and play in some other playground. But the problem with the TikTok ban, and the reason why that's so legally significant, is that some conversations won't migrate anywhere else. They'll simply be lost. There's certain ways that TikTok conversations work that don't work on other environments, and there's certain communities that develop on TikTok that won't replicate elsewhere. So though TikTok will become a ghost town and some people will migrate to other services, there's going to be some conversations that get lost in the equation, and that's the real speech harm.
TikTok's Chinese parent, ByteDance, has made it pretty clear that it doesn't intend to sell the app. Yet we still hear reports of various people putting together deals to buy it. The latest being billionaire Frank McCourt, the former owner of the Los Angeles Dodgers.
Yeah, we don't know what's going on in backroom negotiations. We don't know to what extent they're not able to work out a price, or that the Chinese government is blocking the sale behind the scenes. It's really hard to reverse engineer why a sale isn't happening. But TikTok has been clear all along that that was not its game plan, that it was going to accept a ban over a sale. And from my perspective, the idea of sell or ban is really a ban. And yet the D.C. Circuit was open to the idea. All TikTok had to do was just sell. And from my perspective, I felt offended by that. I felt like that was really tone deaf.
So I guess we'll be talking again on January 10th. Thanks so much, Eric. That's Professor Eric Goldman of Santa Clara University Law School. Coming up next, will Biden issue preemptive pardons? I'm June Grasso, and you're listening to Bloomberg.
President Biden announced that he is granting clemency to approximately 1,500 Americans, the largest act in a single day.
When White House Press Secretary Karine Jean-Pierre announced President Biden's historic clemency package for 1,500 convicted criminals, she emphasized that they'd been convicted of nonviolent crimes like drug offenses, fraud, or theft, had turned their lives around, and deserved a second chance. However, she failed to mention that clemency was also granted to some defendants like former Pennsylvania Judge Michael Conahan, who orchestrated the Kids for Cash scheme to send some 2,300 children to for-profit prisons on false charges in exchange for nearly $3 million in kickbacks. Pennsylvania Governor Josh Shapiro, a Democrat, condemned that grant of clemency.
But I do feel strongly that President Biden got it absolutely wrong and created a lot of pain here in northeastern Pennsylvania.
Joining me is constitutional law expert Harold Krent, a professor at the Chicago-Kent College of Law. How people sometimes confuse pardons and clemency. Explain what clemency is.
Clemency retains the fact of conviction in any kind of problems with convictions that follow ones for life, right to vote in some states, right to hold office, etc. But it allows them to be free of any kind of, either jail time or other kind of oversight, such as probation, drug testing, etc. And he granted 1,500 people this blessing of clemency for those who had previously been released during COVID because of fear of overcrowding in prisons and the fact that they were nonviolent offenders. So it was an easy, objective way to reach out and show some people mercy who, again, had been determined previously were nonviolent and could be released without any kind of problems. So it was a handy way. It wiped the slate clean for the most part for these individuals. But of course, it was somewhat controversial because even though these were nonviolent offenders, he didn't pick and choose amongst them. And so there were some pretty bad actors, let us say, who received the gift of clemency in that 1,500 total.
Yeah, one of the grants of clemency went to Judge Michael Conahan, who got 17 and a half years for orchestrating the infamous Kids for Cash scandal. Pennsylvania Governor Josh Shapiro described the devastating effects of that.
This was not only a black eye on the community, the Kids for Cash scandal, but it also affected families in really deep and profound and sad ways. Some children took their lives because of this. Families were torn apart.
Another grant of clemency went to a woman who was convicted of embezzling more than $53 million in taxpayer money, one of the largest thefts of public funds in Illinois state history. Shouldn't the Biden administration have excluded some of these people with egregious crimes?
Yeah, I mean, the question that should be raised is why didn't this happen all during the administration? So it should have been more ordered, more carefully thought out. I mean, Rita Gronwell, who you just mentioned, was the controller in Dixon, Illinois. And she took $50 million from kids, in terms of the ability to educate them. She returned some of it, but still owes, I think, at least $10 million at least is missing right now still. And, of course, the Pennsylvania Kids for Cash scandal is terrible. And if he had done a case-by-case analysis of who deserved clemency, they presumably would not have received it. I mean, clearly they're already out of jail, and they have demonstrated to some authorities that they aren't likely to commit offense again in the future. But do they really merit clemency, wiping off any kind of oversight they have from probation? That's the question. But he couldn't do that because he waited a long time. It wasn't his priority. And he wanted to do something towards the end of the administration. I don't think he's done. So he just used bright line rules of whoever has been previously released as not a danger, he'll let them wipe off any more oversight from their books.
President Obama granted 330 commutations to nonviolent drug offenders, and that was the most granted in one day in U.S. history until now. I mean, is Biden just trying to achieve a record for the history books?
No, I think it's a recognition that better do something late, not perfect, than do nothing at all. And, I agree with that. It's just too bad that this was not a priority at all, during his administration. And so he had to address this in more of a kind of a ham-handed way because he didn't have the time to decide which of these 1,500 to grant and which not to.
The White House said he's still considering more pardons and commutations, and opponents of capital punishment have called on him to empty federal death row by commuting the inmates' sentences to life in prison, knowing that Donald Trump is going to, once he gets into office, start federal executions again, as he did in his first term.
Yeah, I mean, President Biden campaigned on a pledge that he was against the death penalty. So the question has arisen, why has he taken so long to decide whether to commute the sentences of those 40 individuals who are languishing on death row in federal prisons? Now, there's definitely some bad actors involved in those 40 individuals. There's no doubt about it, including the Boston Marathon Massacre mastermind. But the question is, if you don't believe in the death penalty as a moral basis, shouldn't you be commuting those sentences? And my guess is he will, but again, why take so long?
The focus has been for the last few months, I mean, since he lost the election, whether or not he is going to do preemptive pardons of people who might be targeted by the Justice Department under Trump. Some are saying that would set a bad precedent, but preemptive pardons have been granted before.
So preemptive pardons are part of the president's playbook. Most famous is Gerald Ford's preemptive pardon for President Nixon after President Nixon resigned due to the Watergate scandal. And the way President Ford, wrote that was for preemptively pardon for any kind of illegal activities that he undertook as, President of the United States. So that is a precedent, which is, quite broad. And of course, there was a bit of a preemptive pardon for his son, Hunter Biden, as well. The combined pardon for what was identified in the past, but also preemptively for any 10-year period or so of what he might be charged for. So it's accepted that president's power includes his preemptive power, and that really, is a terrible conflict for those who might be extended it, because if you think you've done no wrong, let's say you're a Jack Smith, do you know that if you take this get-out-of-jail-free card, it helps your family? You don't have to go through public disgrace of a trial and the costs and the pressures of it. But on the other hand, do you look a little guilty? And so there's been a lot of discussions, I'm sure, in the inner circles of the White House and amongst these individuals who've been targeted by President Trump about what should happen. So it's not an easy trade-off. And I think if given a choice, some of those on President Trump's list would say, yes, I'll take the pardon just in case. It's just important for my family. And others would say, never, because I'm never going to look as if I did anything wrong. And it may be that one option is for President Biden just to extend the pardon to those who earlier had said they'll take it, because they don't want to run the risk of all the money, all the bad publicity.
Newly sworn-in Senator Adam Schiff of California, a Democrat that Trump has promised to go after, has said that he doesn't think preemptive blanket pardons on the way out of an administration are a good idea. But he also said many people, including staff in the Biden administration, might have something to worry about if former federal prosecutor Kash Patel is confirmed to lead the FBI.
I think if Patel is made director of the FBI, then all bets are off. I mean, this is someone who will do whatever dirty work the president wants him to do.
But people like Schiff and former Congresswoman Liz Cheney would be protected by the speech and debate clause, though. And prosecutors like Special Counsel Jack Smith and New York DA Alvin Bragg would be protected because they're acting under the color of law.
Yeah, I mean, most of these so-called Trump prosecutions of his opponents are fanciful because, he wouldn't be able to indict them even for a grand jury. And as you mentioned, there's a variety of immunities. Nancy Pelosi and Adam Schiff obviously have the immunity from being members of Congress in their investigations, and the executive officials, the prosecutors, have absolute immunity for their prosecutorial actions, such as Jack Smith, to some extent Merrick Garland as well. So it's really unlikely that President Trump would have any kind of success in prosecuting most of those he's already identified as targets. But, you never know. Maybe there's going to be a state prosecutor who's willing to do the president's bidding who isn't bound by the same kind of immunity doctrines. Or maybe it's just a matter of public humiliation that he's trying to wreak. But I think the chances of success on this political basis are few and far between.
You mentioned the pardon of Hunter Biden, and even when the White House press secretary was announcing this historic clemency package, there were questions still about the president's decision to pardon his son Hunter. And it seems like, in the history books, when they talk about the Biden administration and pardons, the first thing that will be mentioned is that he pardoned his son when he promised he wouldn't.
Exactly. I mean, there are two things about it. I mean, first of all, he said he wouldn't pardon his son and then did it, which, again, looks bad in terms of history. But the second thing is he seems to be blaming his own Justice Department for a politicized prosecution of Hunter. That doesn't go down well with me at all, in the sense that he's sort of abandoning those that he, in fact, has empowered to make those decisions. So I think for that reason as well, pardon of Hunter Biden is going to sit uneasily with many people. Again, the change of mind and the fact that he blamed his own Justice Department for a politicized prosecution.
So now let's turn to Trump for a minute, because he said in an interview published with Time magazine, he said that within minutes or hours of taking office, he would pardon people convicted of crimes related to the January 6th attack. And Trump has been saying versions of that for years. What kind of a message would that send?
Well, he has said that consistently, but he's been inconsistent with respect to whether to offer pardon to all January 6th insurgents, if you will, protesters, or just those who were nonviolent. I can understand the pardon for the nonviolent trespassers, but I think with those who actually attacked officers, I think that would send a terrible signal that you can attack a police officer and the president's going to get out of jail card free.
Through early December, the Biden administration received nearly 12,000 petitions for clemency and more than 1,400 petitions for pardons. So do you think that Biden will hand out more pardons or grants of clemency before he leaves office?
I'm convinced we will, but it's not going to be this wholesale nature as the most recent list of clemency petitions in particular. I think there'll be more targeted individuals, case-by-case basis, those whose pardon applications may have been pending for several years now. So we'll see more, and I'm still guessing that we'll see commutations for those on death row, but time will tell.
The time of less than a month. Thanks so much, Hal. That's Professor Harold Krent of the Chicago-Kent College of Law.
And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.